Welcome, everyone, and good afternoon. My name is Steve Recchia, Vice President at ERS. On behalf of myself and ERS, I would like to thank you all for joining our webinar today, which is titled Bankruptcy and How It Affects Student Debt. This is our third year now of providing the webinars to the higher education community, and I must say we are very pleased with the increasing popularity that we're seeing. In fact, as of this morning, we have nearly 400 people registered for this event, so that is obviously very exciting for us. Before we get started, I do have a few items regarding today's format, starting with the audio or video issues. If you are experiencing problems, please go to the GoToWebinar support, and they'll be able to troubleshoot any issues you're having. Of course, you're probably having audio issues. You can't hear this message right now. So, also, anyone that registered for today's event should have received an email with a link that will take you to a site which you can download today's PowerPoint presentation. The link is http://ersinc.com/2014 the number 1 and the word slides. But again, it should have been within an email. That link should be within an email that was sent to you today. So please go there to download today's presentation if you have not already. And then on Monday or Tuesday of next week, you'll receive another email that will have a link which will allow you to view the entirety of today's presentation. Additionally, if you have any questions at any point in time for our presenter, please use the Q&A text box to submit it, and one of our facilitators, David or Denny, will present the question to the speaker either during or at the end of the presentation. Also, our next webinar topic has not yet been determined, as we're waiting for your post-webinar feedback as to what you'd like to see for the next event. So please take a minute to complete the post-conference survey and let us know what topics you would like to have presented. In fact, today's webinar topic was chosen as a direct result of the post-conference survey from our last webinar. With all that being said, I'd like to turn this over to our hosts and the internationally acclaimed Bursar brothers, David Glazerman and Mr. Denny DeSantis. Denny, please take it away for us.
Thank you, Steve. This is Denny DeSantis, and I'm actually sitting right next to my Bursar brother, David Glazerman from Temple University, and we both would like to extend a very warm welcome to everyone on this nice spring day. So yes, spring is finally here, and we're actually very excited to talk and hopefully learn something about this thing called bankruptcy. Now, those of you that know me know that I always have a story or two, and so let me tell you how I first got interested in this whole idea of bankruptcy. And that was probably about good 25 years ago. We had a bankruptcy case, and this person filed bankruptcy, and they had an outstanding tuition debt of several $1,000s. It was very large. And these were the days before financial responsibility statements and that kind of stuff. Anyway, all those thousands of dollars were discharged. And about a month or so after that, this person came into our office and said, "Hi, remember me? It's time I want to register for the next semester." And it happened to be the person that filed for bankruptcy that we discharged several $1,000s. So it was almost like I was in a Bill Murray Groundhog Day film. So it was, which happens to be one of my most favorite movies. But anyway, and I know there's, as bankruptcies have grown and affected all of us in higher ed, I know there's a lot of confusion and always been, and I've always kind of been confused about things like filing proof of claims and when you should and when you shouldn't, and whether or not there was any kind of direct effect or difference between the type of bankruptcy, whether or not it's Chapter 7 or Chapter 13, as it would affect us in higher education. So there's an awful lot to it, and I know there's going to be a lot of great information that's going to be shared in the next hour or so. But before we get on, I'd like to ask my bursar brother David what his perspective is on bankruptcy. So David?
Well, thank you, Denny, and good afternoon, good morning, wherever you're at in the country today. I think bankruptcy, clearly by the number of people who've taken an interest in joining us today, is really a topic that sometimes can be very confusing. You know, you ask about the notice of stay, you talk about dischargeability, you talk about all the possibilities, and sometimes it can be overwhelming, even for people who've been in the business for a long time. So what we really want to focus on in the next hour and 15 minutes is to give you a complete overview on how bankruptcy affects student debt, looking at student loans, looking at tuition and fee accounts. We'll be taking questions again as we go forward, and if you have any questions, if you would just submit those into the question box that you'll see on the right side of the screen, we can go from there. So I'd like to turn the session over in just a second to our presenter today, Ed Berger, who you see is a graduate of the State University of New York at Albany. Ed's been involved in dealing with student loan and receivables collections now over 30 years, but specializes in an understanding of how bankruptcy affects student debt in total and how, what's involved with dischargeability, what's involved in the whole process. So without any further ado, Ed, I'd like to turn this over to you.
David, thank you. Can you guys hear me fine?
You're doing
Hello?
well, Ed.
All right. I just want to thank the folks at Enterprise Recovery Systems and, of course, the Bursar brothers, David and Denny. Thanks so much for having me today. This is my first webinar. I'm grateful for the fact that I've not taken any embarrassing home videos or selfies, so there's nothing out there on me other than the usual people I collect from who will post that I'm nasty and things like that, but I don't hold that against anybody. As I said, I usually work with a live audience. I'm presenting live, so if you all try to be live today, I would greatly appreciate it. I also wanted to thank Heather and Kim for all the work they did in assisting me in the preparation of the PowerPoint as well as the handout materials. So let's talk about the introduction, the nature and purpose of the bankruptcy laws. Guys, the screens are, there we go, okay. Introduction, nature and purpose of the bankruptcy laws. The whole reason for bankruptcy is not to frustrate or annoy debt collectors or student loan collection people. It is to give the debtors a fresh start. Bankruptcy, the right to file for bankruptcy, is granted by the United States Constitution. I'm sure everybody here is familiar with the Constitution intimately. And we're going to talk a little bit today about how we first get notice of a bankruptcy filing. There are many ways. We receive a notice in the mail, and that pretty much sums it up. It will typically tell you what type of bankruptcy it is. It will say it's a Chapter 13 or a Chapter 7. Very, very, very rare instances will it talk about an 11. So let's just focus on Chapter 7 and Chapter 13 bankruptcies. So other than receiving a notice in the mail from the court, oftentimes we will hear from the student, from the debtor, and I'll use those words interchangeably because once somebody files for bankruptcy, they become a debtor in the eyes of the court. I would refer to them as deadbeats, but I don't want to be offensive. So oftentimes we'll be on the phone with a debtor or a debtor's attorney, and they'll tell us that they filed for bankruptcy. Now, I don't know about you, but I do some collection work, and I don't always believe debtors when they tell me something. So even if a debtor tells you they filed for bankruptcy, you try to get some information from them. It's okay to ask them some questions. Actually, you want to try to get from them the information that would have been contained on the bankruptcy notice, and that is, what court did they file in? There are many bankruptcy courts. Most states have multiple bankruptcy courts: Eastern District, Middle District, Southern District. So ask them where they filed. New Jersey, unlike many other states, just is the District of New Jersey, but there's the Camden vicinage, the Newark vicinage, Trenton vicinage. Ask them where they filed. Also, you want to ask them the case number. You want to ask them the bankruptcy case number, which typically starts out with the first 2 digits of the year in which it was filed, i.e. this year would be 14-12345. So it's okay to ask them the bankruptcy case number. You also might want to ask them if it was a Chapter 7 or a 13. Again, if you received the notice in the mail, it's telling you all of this. The other way to find out this information is to go online and check PACER, and when we get to the end of the presentation, at the end of the PowerPoint, there is some information about the PACER system, and that's P-A-C-E-R, PACER. So let's distinguish between the different types of bankruptcy. The first and most common type of bankruptcy is a Chapter 7 liquidation, which typically means that all of the student debtor's assets will be sold to pay off creditors. The other major type of bankruptcy is a Chapter 13, and a Chapter 13 is an individual reorganization. Chapter 13s are where we have to file proofs of claim, and we need to do that in order to share in some distribution along with other creditors. Let's talk a little bit about Chapter 7. Once you receive notice of the bankruptcy of a Chapter 7, you've either received a notice in the mail, the debtor has told you that they're filing, you've seen it perhaps on a credit report, or the debtor's attorney has sent you a letter. What do we need to do? We need to centralize this information. If you at your institution have separate offices that collect student loans and separate offices that collect tuition, you need to make sure that both offices are aware of the bankruptcy filing. Please tell your agencies or attorneys and your billing servicers, if they don't know, about the bankruptcy filing. All of this information has to be networked. If you have, and I hope I'm not saying anything out of turn here for the good folks at ERS, but if you have a contract with your agency, I presume it deals with bankruptcy notices, that they will advise you of the bankruptcy in a very timely manner. So they should be advising you, and conversely, you should be advising your collection agencies, your loan servicers, ACS or Xerox, or who took over ACS? Xerox. Some of the other loan servicers out there, you have to let them know. And again, in your office, at your university, if there are other offices or institutions that are charged with dealing with student debt, student receivables, they need to be made aware. All right. Once everybody's aware of the bankruptcy, we stop billing, we stop communicating, we cease all collection activity. Now, that does not mean interest stops accruing. Interest continues to accrue, and by and large, student loans are non-dischargeable presumptively. That means automatically. And the loan will remain validly due and collectible once the bankruptcy is concluded. Now, again, we're talking about Chapter 7 bankruptcies. If somebody is past due at the time of a bankruptcy filing, 1 month or 2 months past due, until the bankruptcy is concluded, they cannot be falling further behind. No additional payments are coming due. Interest continues to accrue, but that interest has to be put back at the end of the loan. I hope everybody understands that. The billing servicers, I'm sure, do understand that. Okay? Let's talk a little bit about why Chapter 7 bankruptcies take so long and what happens in a Chapter 7. Many of you have seen the notices from the court that says this is a no asset Chapter 7. Well, Ed, you just said that a Chapter 7 is a liquidation and they sell the assets and pay off the creditors. Well, that's how it's supposed to work, but in my 30-odd years of handling bankruptcy cases, I've probably handled 300 Chapter 7 cases, or maybe 1,000, and the number of times that I've seen any assets ever appear in a Chapter 7 case, I can count on one hand. Now, in a Chapter 7, if there does subsequently become assets available, you'll get a separate notice from the court that says, hey, assets have now been found. Okay, but the typical Chapter 7 notice, does, will say this is a no asset bankruptcy. Right. Can we go to the next slide, please? Guys? All right, thanks. Next one. All right, thank you. Chapter 7 liquidation. The debtor will liquidate all non-exempt assets. Well, what does that mean? You could be on your campus and see one of the students that you're attempting to collect from driving around town in a late model automobile. Will he have to sell that automobile in order to pay off his creditors if he's filed for bankruptcy? The answer to that question is almost definitely not. The theory is that somebody typically buys a car like that, they finance it, and there's very little equity in the automobile, which means that the bank or the finance company essentially holds the title, and there would not be any amount there that would be realized by a creditor if it were sold. The only person that would get any money from that is the person who lent him the money to buy it in the first place. Same thing is true with a home. The typical situation is for homeowners, they own their home, the deed may be in their name, but if there's a lien, a mortgage against the house, that would reduce, if not eliminate, any equity in the home. I'm sure today everybody knows about the properties that are being underwater or upside down, which means that the balance that they owe on the mortgage loan exceeds the value of the property. Again, I point out to you that if somebody had any equity in a car or a home or other piece of property or other valuable asset, they wouldn't be filing a Chapter 7. So the large majority of Chapter 7 cases are, quote, no asset cases, and the notice that you will see from the court says do not file a proof of claim at this time. All right. It typically takes several months for the Chapter 7 case to proceed. There's case administration. The court will ask the debtor to come in and answer some questions in front of a trustee. Creditors are allowed to attend, and student loan creditors typically do not attend. But again, creditors are allowed to attend this meeting of creditors. That's why it's called a meeting of creditors. It's authorized by the Bankruptcy Code. After the meeting of creditors is conducted, the bankruptcy trustee will file his report. He'll examine all of the debtor's paperwork, and there will be a determination typically of dischargeability. Next screen, please. All right. Talk about a determination of dischargeability as it pertains to student loans. Student loans and other educational benefits are not dischargeable, presumptively not dischargeable. Now, there are exceptions. Aren't there always exceptions with attorneys? Student loans are not dischargeable provided that the repayment of the student loan does not cause an undue hardship. Next screen, please.
Ed, well, before we go to the next screen, there was two questions that come out here. One is about, are there any differences in statute of limitations on reporting debt to the credit bureau versus using a collection agency to report that, which we can take up later? But I think a key question during the cycle with notice of stay that you're going to talk about, do universities have to provide transcripts during the bankruptcy period?
Yeah, we're going to talk in a very short period of time about transcripts and transcript requests, readmission to school, reborrowing, things like that. When you talk about the duration of the reporting period, Dave, that was the first question you had asked me?
Yes.
I don't want to confuse the statute of limitations with credit reporting. Credit reporting only lasts, it's my understanding, for 7 years. If things drop off a credit report after 7 years. That's not the same as a statute of limitations. If the question is, does bankruptcy affect the terms of the credit reporting, I don't know the answer to that. All I can tell you is when somebody files for bankruptcy, that appears on their credit bureau profile. That's a public notice, as is an IRS lien and a judgment. And typically, that'll stay on there for 7 years. Okay? I don't know if anybody has any further questions about that. Perhaps we can address it at the end. We will talk about transcripts and how that's affected by bankruptcy filings in a minute. Okay?
Okay, and we had another question asking about tuition, and I know you're going to take that up later, too.
Right. We will. We'll talk about tuition. Right now, let's just talk about student loans. And we were talking about the one exception to the general rule that student loans are non-dischargeable, and that is if the student loan or educational benefit, the repayment of the student loan would present the student with an undue hardship. Okay? We'll talk about that in a second. Everybody's interested in knowing whether or not a particular debt is dischargeable. If it's a tuition, which is a book account not evidenced by any contemporaneous promissory note, and contemporaneous means at the same time, tuition accounts commonly are created when somebody's financial aid falls through, which almost by definition means that they were anticipating financial aid, they were anticipating not having a debt to the university itself. However, they didn't get as much as they anticipated, and a tuition obligation has been created. Or there's been a shortfall, the parental contribution was not there where it should have been, and there's an outstanding tuition debt. If there is not a contemporaneous writing that accompanies the outstanding tuition obligation, it is going to be dischargeable wherever you are. Some jurisdictions are a little bit more lenient with their writing requirements. Some schools I know, for instance, will have somebody sign a document after the fact, after the debt is created, and if they want to continue with the next term while their financial aid is still being processed, or whatever the case may be, the school will then have them after the fact sign a document which they want to use as a writing, and can we use that to make the debt non-dischargeable? The answer, unfortunately, depends on where you are filing your bankruptcy petition. Many of you are going to ask, well, if somebody signs up and incurs a debt online, they register online, they read everything that we say that says if your student loans fall through, that this is an obligation that you owe. That is contemporaneous, and that is writing, even though it's online. They've checked off they agree with these terms. That is a contract. Honestly, I've never seen that litigated. There are jurisdictions in this country that would probably consider that to be a non-dischargeable debt. Most jurisdictions, including New Jersey and Pennsylvania, would not consider that to be non-dischargeable. That would be dischargeable. Hopefully everybody understands that. We will talk more about this in detail. I did want to get back to the dischargeability based on hardship. Unfortunately, Congress did not define undue hardship. Next screen, please. Well, next screen. All right. Student loans receivables presumptively non-dischargeable. Some receivables, again, depending based on the jurisdiction, will be dischargeable. Unfortunately, that is most of the jurisdictions across the country. We're talking about library fines, always dischargeable. Dormitory fees, typically dischargeable. Parking violations, things of those nature, that's going to be dischargeable. The tuition itself is what we were talking about when we were talking about it had to be accompanied by a writing. But I want to talk about now the undue hardship. Congress did not define undue hardship. Has anybody here had a situation where they've received an adversary complaint? I can't hear your answer, so I'll assume some of you have. If somebody wants to try to determine or try to have the court determine that a student loan should be discharged as a result of a hardship, they will get served with an adversary complaint that will say adversary complaint to determine dischargeability based on hardship. And then the court will have to make a determination as to the dischargeability of the debt. 99 times out of 100, it's difficult to make out an undue hardship. Let me tell you some of the situations that have to exist. The student or the student's dependent needs to have some sort of terminal illness, AIDS, cancer, some sort of debilitating situation which came on after the debt was incurred. Now, most of you who deal with loans know that, if a hardship, if a disability arises, you can administratively cancel most of these loans. So most of the student loan bankruptcy attorneys out there know this as well. So rather than filing an adversary complaint, they'll just have their client try to discharge the debts by filing the appropriate cancellation paperwork. The sheer magnitude of the student loan debt is almost never enough to get it discharged. Okay? Let's talk a little bit about post-bankruptcy proceedings. Next screen. All right. Next screen. Okay. Institutional strategy in Chapter 7 cases. Again, Chapter 7's almost never an asset case. You don't have to bother with proofs of claim. Is it wise to contact the attorneys and let them know that the debt would be non-dischargeable? Yes, typically that would be a good thing. This day and age, most bankruptcy attorneys know that the student loan is non-dischargeable. If the school has an articulated policy of withholding records for defaulting students, and the student was in default at the time of the bankruptcy, I presume there was a stay, there was a financial hold on their account. If the student was not in default at the time of the filing, or if the student was in default at the time and for whatever reason the university just did not have a hold on there, you cannot change the status. You can't place the hold after the bankruptcy has been filed. If the school has an articulated policy of withholding records for defaulting students, do not automatically change this if the student files for bankruptcy. If the student contacts you or the student's attorney contacts you and says, look, we're during the pendency of the bankruptcy, my client would like his transcript, even if it is a non-dischargeable student loan, you do need to honor that request. Do it on a case-by-case basis. Take the hold down just for that one time only, and go ahead and issue a transcript. Just do a waiver. Okay? Leave the hold on. I'm sorry if I said take the hold. Don't take the hold down. Just issue a one-time waiver to whoever the student requests during the pendency of the bankruptcy, regardless of whether it's a dischargeable student loan or non-dischargeable. Does everybody understand that? If not, please submit a question. We'll discuss that in a little more detail. All right. Again, only file a proof of claim if it's a Chapter 13. We'll talk about that again. The student can we receive payments, can we accept payments from students even if we know they're in a bankruptcy? The answer is yes. There are times when students who know that their debts will remain non-dischargeable, want to stay ahead of the game, or if they're current at the time of the filing, they can continue to make payments. You can accept those payments. Do not send those payments back. But you cannot bill the student. Your billing servicer, your collection agency cannot bill the student. However, they can accept payments.
Ed, we have two questions that might be relevant at this point. One
Okay.
related to student loans. If somebody files for a deferment in bankruptcy, can that be processed?
If somebody is attempting to defer payments during the pendency of a bankruptcy, is that the question, David?
Yes.
I would submit that yes, that you probably could do that. That certainly wouldn't be to the student's detriment. It doesn't make sense because payments aren't coming due to be deferred, and deferments don't, as far as I know, deferments don't have any effect on interest, just on principal payments. So I don't understand why somebody would submit a deferment during the pendency of a bankruptcy, but yes, you could go ahead and process that. That is not anything that's happening that's detrimental to the student. That is at the student's own request. One would anticipate that if the student filed the bankruptcy and requested the deferment, that's something they want. So sure, you can go ahead and process it. I don't know when that would ever arise. What was the other question, David?
Okay, the other question, going back to the issuance of the transcripts, this
Right.
is, I'll just paraphrase this. If the school has a policy that no student will get a transcript or have grades issued with a balance due, does the institutional policy or does the bankruptcy code take precedent?
The bankruptcy code takes precedence. No ifs, ands, or buts about that. Just as if somebody were, in the process of having their driving privileges suspended, a bankruptcy would place a hold on that. If during the pendency of the bankruptcy, transcripts requests need to be honored. There's no question about that. Does everybody understand that? Okay.
Hey, Ed?
So,
Ed?
yes.
One more.
Yes.
Previously, we were talking about the FCRA, we're talking about the credit bureau, and I just want to clarify one thing. It was my understanding, I went to the Experian website and the FICO's website, that a Chapter 13 will last on the credit bureau for 7 years, as you indicated. However, Chapter 7 will be on the credit bureau for 10 years. So I just wanted to clarify that.
Okay, I appreciate that.
Okay.
So basically what you're saying as for purposes of the Fair Credit Reporting Act, the Chapter 13 will stay on there for 7 years and the Chapter 7 will be on there for 10 years?
You got it.
Okay, thank you.
Hey, no problem.
I always learn things when I do these presentations, and it's easier, and I appreciate that. I don't know who that was. That wasn't Denny. Who was that?
Steve.
Steve, thanks. I can't, obviously I'm not getting direct feedback from the audience, so I can't learn things that way, but perhaps after the session, if anybody wants to email me, on one of the screens my email information is contained, and I will gladly respond to your email requests if it's reasonable. If it doesn't include taking my clothes off. All right, so we do need to honor transcript requests. Do not take your hold down. Do not take your hold down. Just do a one-time release on an individual basis. Does everybody understand that? All right. Let's talk about Chapter 13s. A Chapter 13 bankruptcy, I'm sorry, let's advance the screen here. Next one. Thank you. All right, Chapter 13s. Chapter 13s can last up to 60 months, 5 years. That's because the student, the debtor, is proposing to repay most of his unsecured creditors. Again, we need to understand as student loan people that people file bankruptcy for many reasons, almost never solely because they have student loans, because as I said, student loans are non-dischargeable. However, if something nasty is happening, even if it's on a student loan, if I'm attempting to attach somebody's wages or freeze somebody's bank account, they may very well go into bankruptcy, which will buy them some time. But for student loan obligations, ultimately, I will be able to, once the bankruptcy is concluded, go back and collect the debt. But Chapter 13s can last up to 5 years, 60 months. Now, what should we do? Institutional strategy. Next screen. Thank you. Institutional strategy in Chapter 13. You must file a proof of claim in order to share in any planned payments. The filing or non-filing of a proof of claim will have absolutely no effect on the dischargeability or non-dischargeability of your obligation. You cannot take an otherwise dischargeable obligation and make it non-dischargeable. However, if you have a library fine, if you have dormitories or parking fees, anything that the student owes other than a student loan, and the student files a Chapter 13, you may receive some amount of money through the Chapter 13 bankruptcy if you file a proof of claim. How do you file a proof of claim? Well, I'm glad you asked. Oftentimes, the bankruptcy court themselves will send a proof of claim form along with the Chapter 13 filing. There used to be eons ago something called legal stationery stores where you could purchase a proof of claim form. Now, I believe we just download them. So the proof of claim forms, I'm sure, are available online. I, of course, have blank forms if anybody needs one. You fill it out. It's fairly straightforward. You do want to, when you file it, attach copies of your student loan promissory notes. And you put in there the total amount that would be due, not just a past due balance. Put in the total amount that would be due. Does everybody understand that? I can't hear you. Good. All right. So the filing of a proof of claim or the non-filing of proof of claim does not affect the dischargeability. All right. You might want to contact the student's attorney to see if they're going to pay any of this inside the plan or if they're going to choose to pay it outside the plan. What does that mean? A Chapter 13 is administered by a trustee, a representative of the court. The Chapter 13 trustee collects payments from the debtor. Oftentimes it's in the form of a wage execution, wage garnishments that automatically go to the Chapter 13 trustee. And the Chapter 13 trustee then distributes that money to creditors. Typically, priority and secured creditors get paid first. That would be the debtor's attorney, not surprisingly. Taxing authorities, fines and things like that if they owe money to various government entities, that would be a priority debt. And then secured debt if they have a mortgage or if they have car payments that they're behind on and they want to keep their automobile, they want to keep their home, they do need to continue to make payments. They'll be making payments outside the plan, but they would also be making payments through the trustee. The trustee will also make payments to unsecured creditors, all of the colleges and universities out there that file proofs of claim. Hope everybody understands that. You want to file the proof in duplicate. Request that they send you back a time-stamped copy so that you have it for your records. Make sure that the trustee gets a copy of the proof of claim. It's not a bad idea to send one to the debtor's attorney. Do not, repeat, do not send it to the debtor unless the debtor is acting as his own attorney, in which case you may do that. Okay? Again, the filing or failure to file a proof of claim will not affect the dischargeability of the debt. If you have a Perkins student loan or a guaranteed student loan or some institutional student loan, and you do not file a a proof of claim in a Chapter 13, that does not bar you from collecting your non-dischargeable debt at the conclusion of the bankruptcy case. Okay? All right. Let's talk a little bit about transcripts and registering for classes and things of that nature. Again, during the pendency of the bankruptcy, and Chapter 13s can last up to 60 months, 5 years. The student is entitled, in most jurisdictions, even with a non-dischargeable debt, to receive his transcript. The one exception out there that I am aware of is in New Jersey, and this, David, you'll be interested to know, was a case on behalf of Rutgers, I believe. Rutgers had a student. Was it Rutgers or Temple, Dave? I don't remember now. Ellen, if you're listening, it was one of your cases. Rutgers had a student who was in Chapter 13 and requested a transcript. And I went up to Trenton on behalf of the school and tried this case, and the court bought my argument, despite all the law out there in other jurisdictions, that during a Chapter 13, the student should get his transcript. Again, in New Jersey only, it appears to be still good law that you can withhold transcripts. I wouldn't do it in any other jurisdiction.
Ed, that was a Temple case, and that
Temple
was somebody
case.
that filed 2 or 3 times just trying to avoid the debt.
Okay. And maybe that's why the court ruled in our favor that time. Thanks, Dave. You do remember that one?
Very well. We like our
All right.
victories.
Yeah, right. Let's talk about, is the student entitled to additional credit? Can he register for classes if he's got a dischargeable or non-dischargeable debt and he's currently in a bankruptcy? Well, you cannot, let me repeat that, you cannot discriminate against somebody simply as a result of a bankruptcy filing. If somebody owes you money for a tuition obligation and they're currently in a bankruptcy and they want to come back to school, you cannot prevent them from registering. You cannot prevent them from registering. What you can do is demand that to be paid up front. I hope everybody understands that. You can demand to be paid up front before they walk in the door for their first class. What about the bankruptcy's over, the debt is dischargeable in bankruptcy? If it were a tuition debt, a library fine, dormitory, something along those lines, again, you cannot require that they pay that in order to register for the new classes. However, you can demand that they pay for any new classes up front. Now, my understanding with federal entitlement to federal student loans is that you can, after in the event that you've gone through bankruptcy, you've gone through Chapter 7, you've gone through Chapter 13, that will not disqualify you from obtaining student loans in the future. If there's anybody there that thinks differently, let me know. But federal financial aid will not be prevented, will not be withheld as a result of a bankruptcy filing. What about diplomas? A diploma, much like a transcript, can be withheld after the bankruptcy is concluded for a non-dischargeable debt. If it's during the term of the bankruptcy, unless you're in New Jersey, and somebody requests a diploma, you have to honor that request, unfortunately. Okay? All right. Guys, that's pretty much it. I would be happy to address any questions that you guys have on an individual basis. Dave, were there any other questions?
Ed, we have a bundle of questions here, so
Okay.
I'm going to try and summarize these in no particular order. We're talking about tuition. One of our questions was, is outstanding tuition a dischargeable debt? I think you just mentioned that, but if you could repeat your answer.
Sure. Depending on where you're located, and the answer to that is tuition is dischargeable unless there is a writing that accompanied the tuition obligation, not after the tuition obligation, but at the same time as the tuition obligation. If there is a writing, it is non-dischargeable. That being said, it could very well cost you quite a bit of money to prove that if the student attempts to file an adversary complaint. If you have a contract that is entered into contemporaneously at the same time that the tuition obligation is created, the debt is non-dischargeable.
Ed, that leads into another question we had earlier, and this is regarding, again, when you talk about having a rating prior to tuition debt being incurred. Many schools are using financial responsibility statements or promissory notes or something. The questioner asks student financial obligation agreement, something the student might do online right before they register initially for their classes. Under
David,
that scenario,
if it's done at the same time or before the debt is incurred. So again, I thought I had addressed this. If I didn't, in this day and age, people are registering online. People are clicking the box that says they agree to all these terms and conditions. And I know when you go online and you buy something online from Zappos, you always read all the terms and conditions. And we're assuming our students read all the terms and conditions. And one of those terms and conditions probably says that if your financial aid falls through, this is a debt that's justly due and repayable. There may be attorney's fees if we have to place it with an agency. There may be interest in the event of a default. If that's created, if that is agreed to at the time that the debt is created, at the time of registration, then you can take the position that it is non-dischargeable. Did that answer that question, Dave?
I believe that does. And if the questioner once has a follow-up, if they just type that into the question box. And you mentioned we were talking about federal student loans. Can you just rate back a couple questions here related to private or institutional student loans and their dischargeability?
Institutional student loans, again, we're talking about institutions of higher education, not-for-profit institutions of higher education. That is not the same case with proprietary schools. If you're an institution of higher education, not-for-profit, even if it's your own institutional loan program, the Temple University Alumni Fund loan program, that is entitled to the same protection under the Bankruptcy Code, and the student loan is equally non-dischargeable, presumptively non-dischargeable. It is not just federally funded student loans, but all student loans for not-for-profit institutions of higher education.
I think this is a good point to mention, too, that if you're following proposed legislation in Congress, there is a bill that would take non-federal student loans and make them subject to discharge. That is just a bill that hasn't really gained any traction yet in Congress, but it is out there, and you'll hear this from some consumer advocates and student associations who are really pushing for that legislation to pass. But again, it's important to reiterate that is not the case today.
Right.
Another question. Go ahead.
Go ahead, Dave. Sure. No, go ahead, Dave.
Another question we have is there a good source of information for a layperson on the topic of bankruptcy as a follow-up to today?
Funny you should mention that, Dave. Bankruptcy and how it affects student debt. I believe that Kim and or Heather made available to the people who have signed up for this webinar some sort of handout or outline which you can use as a resource. Dave, do you know if they have that available?
Everybody who registered today should have gotten an email with a link to the PowerPoint presentation and to that supplemental guide.
Okay. Other than that, if you're asking if there's a bankruptcy for dummies, there may very well be, but I've not seen one. You know how they have, the tax code or Windows for dummies. I've never seen the bankruptcy code for dummies, although many people would argue that a lot of the bankruptcy attorneys out there qualify as dummies. I don't know of anything, of that nature.
Okay. Thank you, Ed. We're just taking questions now. Pretty much, no particular topic, just sequentially. We talked about private loans and tuition. Could you just repeat, if these debts are outside of statute of limitations right now, does that have any effect on the bankruptcy process or their dischargeability?
All right. The bankruptcy process can impact and toll or stop the running of the statute of limitations. If you have a non-dischargeable obligation and somebody goes into bankruptcy and they're in bankruptcy for 5 years, as they can be in a Chapter 13. They go into bankruptcy, they come out of bankruptcy 5 years later, the student loan is still there. They default. It's now 2 years after they were out of the bankruptcy, but it's 7 or 8 or 10 years after they've, after the loan first came due. The statute of limitations will be told, it will be stopped or interrupted based on the entire duration of the bankruptcy filing. Was that the question?
I believe so. Again,
Okay.
for the person who asked that, if you have a follow-up to that, you just type that into the question box, and we'll try and get back to that before we're done today.
Okay. In other words, somebody graduates in 2010. Their loan comes due in January of 2011. It's past due for 2 years, 3 years. It's now 2014. They go into bankruptcy. They could be in bankruptcy, and this is, again, a student loan. They could be in bankruptcy for 5 years, so now we're looking at 2019, which is 8 years after the loan first came due, or 7 years after the loan first came due, which would be outside the statute of limitations, but for the fact that they filed for bankruptcy. The duration of the bankruptcy would toll or stop the statute of limitations.
Okay. Thank you, Ed. Now, we have another question. This is from Holly West about a situation. This is a specific school situation where a parent made payments toward a student's account during the bankruptcy proceedings, and the trustee is requiring the funds to be returned. Holly's question was, how would this be different than making a payment toward a debt during a bankruptcy?
I just want to clarify. A parent, somebody who's not the debtor, was making payments on a non-dischargeable loan while the bankruptcy was going on, and now the trustee is requesting the payments be returned?
It doesn't say if this was not, what type of debt this was.
Okay.
Presuming I see student account. I'm presuming that's a tuition account.
Let's presume it's a tuition account. If the payments were made by the student, to the school on a dischargeable tuition account, the trustee could try to have those payments turned over to the trustee, not returned to the student, but turned over to the trustee. If it were a third party making the payments, which I think was your question, if it was a non-debtor, somebody other than the person who filed the bankruptcy petition, those funds would not be returnable to the trustee or to the debtor. The school could keep those funds.
Excuse me, and Holly just clarified, the payments were made by the parent, and the parent was the one in bankruptcy,
okay.
not the student.
Was this, if this is a parent plus loan, or the parent was, okay, I understand. The parent was in bankruptcy making payments on their kid's debt. Holly, is that the situation? If that was I don't know if that was, let's assume that was the situation.
Well, it sounds like that was the situation. The parent was paying for the student.
The parent was paying for the student, and the parent was in bankruptcy.
Right. Parent was paying on the student's account, and the parent went into bankruptcy.
And the parent went into bankruptcy. I would think that the trustee could try to get that money paid over to the court. But if I were the school, I would definitely retain an attorney to challenge that. If I were the school,
in essence, it sounds like the parent was trying to, was taking money that would have gone to other creditors. And paying off their child's obligation so that their child didn't have this obligation anymore. And I think it's important to differentiate here. The student is responsible for their account. Whether who pays that tuition bill is really a separate issue. Is that correct, Ed?
Exactly. I mean, anybody can pay on behalf of somebody else. Just because a parent voluntarily undertakes the payment of their child's debt doesn't mean their child is no longer liable down the road. I mean, I get that question more often in non-bankruptcy context because obviously I do debt collection work as well as student bankruptcy work. Student incurs a tuition obligation. Parents been paying since the student was a 17 or 18-year-old. Now the student is 37 years old, and mommy and daddy are still paying. That does not get the student off the hook. If mommy and daddy croak, if mommy and daddy stop paying, if mommy and daddy have a falling out with the student is still on the hook. Okay? But in the situation, it's called a preferential transfer. If somebody who's in bankruptcy pays one creditor, whether it's their own creditor or not their own creditor, to the detriment of other creditors, the trustee is entitled to recover those preferential payments. If we're talking about a lot of money, I would absolutely fight that because it's almost always something that the trustee will settle.
Thank you, Ed. Another question, going back to the responsibility statements on tuition accounts.
Yep.
I guess this Angie Lane is asking us to clarify, if the student signs a paper document, the unpaid portion of tuition and fees is dischargeable, but if the agreement was done online, it's not dischargeable?
No, if it's a paper document created at the same time the student incurred the debt, it's non-dischargeable.
So it could be the affirmation of the debt prior to the registration.
Prior to or at registration.
Statement, whether that's done in paper or in an online format, would be acceptable.
If it's creating a contract, the answer is that should be acceptable to take the debt out of the dischargeable category. That's correct.
Okay, thank you, Ed. Another question we have, we're asking, the question is to clarify your statement regarding interest continuing to accrue, but the number of delinquent months not increasing during the course of a bankruptcy proceeding.
Absolutely. Let's presume, and again, we're talking about an installment contract where payments are coming due monthly or quarterly, as the standard student loan payments are. If the student is 3 months past due as of the date of filing, once the bankruptcy is concluded, whether it's a Chapter 7 and it can be concluded in 2 months, or a Chapter 13 that's concluded in 60 months, the student will still be 3 months behind when he comes out of bankruptcy. Now, that means principal payments are not coming due. Interest continues to accrue, but it is not all due and payable. If the student is in bankruptcy for 60 months, the interest that accrues over 5 years is not immediately due and payable when the student comes out of bankruptcy. That just gets added to the end of the debt. It's the past due amount. It's a freeze. The bankruptcy filing creates a freeze in time. Whatever the amount past due is as of the date of filing is the amount past due the day following the conclusion of the bankruptcy. Principal payments do not come due. Interest continues to accrue, but it is billable and payable at the end of the loan term.
Okay. I think that answers that question. Thank you, Ed. Let's go. We've got another one here. This is, again, clarification. If there's a balance due resulting from a refund that was issued to the student for excess financial aid on a student's tuition account, would that be considered dischargeable?
Okay. And again, that's a typical way that obligations are created to the universities. An overpayment, if it's an overpayment that the student was not entitled to, should not have gotten. David, was that your question? Repeat it?
Yes.
Okay.
Where they were over-awarded, they were given too much financial aid, or money was taken back. I think this question really looks at the term here is excess financial aid. The school had to return student loan or Pell monies to the Department of Education because the student dropped classes.
Okay.
They were.
I would take the position that that's non-dischargeable, that was created pursuant to a program, and there's case law in the District of Virginia. Is Connie still in the industry, Dave?
No.
You know who I'm talking about, right?
Virginia Commonwealth.
Right, at VCU. There was a case in Virginia, I think, that dealt with this type of case where, pursuant to whatever the regulations are, there was a money that had to be refunded to the federal government, to the bank, to whoever it was, but that created a shortfall in the student's tuition account. As long as that paper trail was clear, I would take the position that that is non-dischargeable. Now, that doesn't mean that it might not cost you some money to arrive at that determination, i.e., to get an attorney to represent your institution to take that position, because many debtors' attorneys would not agree with that, obviously, but I do think that in the majority of jurisdictions in the country, that very narrow scenario would be non-dischargeable.
Okay, thank you. I want to give you a chance to take a breath. There's a question out here about a website to look to see if the student's in bankruptcy if you've not been notified, and Pacer is the place we would suggest that you look for that information. And again, on that, we have a slide in the presentation that talks about Pacer. But then what happens in the case if the school never is notified about the bankruptcy? What is that possible, number one? And I guess number two, the follow-up question is, what responsibility does the school have to pursue that type of a student or a debtor claims bankruptcy, but there's no filing or no evidence of that?
All right, well, if there's no filing, then there's been no filing. But if there's been no notification, let's take the situation where the student went to Temple University and incurred a tuition debt without any contemporaneous writing, and it would be dischargeable. However, if it would be dischargeable if it was listed in the bankruptcy and Temple was notified. If it's a Chapter 7, Dave, if it's a no-asset Chapter 7, most bankruptcy courts have taken the position that if it's a no-asset case, think about this, if it's a no-asset case, what difference does it make if the creditor is notified or not? It wouldn't matter. Hopefully you understand my reasoning. And that's the court's reasoning. If there's no assets, it doesn't matter if you were notified or not. The debt's going to be dischargeable, whether you're notified or not. If it's a non-dischargeable debt, then it's not affected by the bankruptcy in any event. If it's a Chapter 13 case and the creditor is not notified, you check the bankruptcy filings, you check the schedule of debtors, the matrix that's filed with the bankruptcy filing, and if the creditor, the university, the college, is not listed, then the argument is that debt survives the bankruptcy, even if it were dischargeable. If this is a Chapter 13, somebody owes Temple University money for a tuition obligation, and you're attempting to collect it, the person goes into bankruptcy and doesn't let you know if it's a Chapter 13, so that you could have had the opportunity to share in the proceeds of the repayment, the reorganization, file a proof of claim. Once that bankruptcy is concluded, you can take the position that the debt is non-dischargeable. Did that answer the question, Dave?
I believe so.
Okay.
Let's pull up the next question. During a Chapter 7 bankruptcy stay, Ed, does the school have to release more than one transcript?
Yeah, the answer is if you have to release one, you have to release multiple transcripts. Now, don't get me wrong. If there's an administrative fee that they pay to your registrar, you can collect that. That's collectible. I'm not talking about paying the debt itself, just the fee for mailing out the transcript. The answer is yes. If you have to release one, you'd have to release multiple ones. And during the pendency of a Chapter 7 in all jurisdictions, yes, you have to honor transcript requests on a case-by-case basis, even if it's multiple requests.
Now, does it matter if it's an unofficial or an official transcript given to the student?
I mean, and again, I'm not talking about what FERPA says now. Why would the student be requiring an unofficial? Why would the student be requesting an unofficial transcript? I mean, they can. Oh, correct me if I'm wrong. They can always view their grades. You cannot deny them access to view their transcript. But to receive an official transcript, if there's a hold on, then the hold stays on. If they're in bankruptcy, you take the hold down, and on a one-time only basis, or a two-time or three-time or four-time only basis, but do not take the hold down so that they can get unfettered access to it, because once the bankruptcy is over, you don't want to be in a position where you then have to discover that and put the hold back on. So you leave the hold on and you honor the requests. Should there be any difference between an official and unofficial transcript? No.
I think probably just from an operational standpoint, if the student's making a request, usually it's going to be for an official transcript, even
right.
if it's within the institution. They're
right.
going to, the provider is going to want, or I should say the person who's supposed to be receiving it is going to want to see an official, I would believe. Back to the financial responsibility agreements up front on tuition, does that agreement need to indicate the cost of the semester for the student? Specifically talk about the amount of debt that's being incurred?
Because we're talking about kind of the fringe of what's dischargeable and what's non-dischargeable. My answer to that question is the contract, whether it be a writing or something created online that's created at the time the debt is incurred or before the debt is incurred, the more information, the better. It's got to be specific as to how much of a debt, again, because it's going to be created at the time, it may very well be that you don't know exactly how much the student is going to owe. So if it just refers to any outstanding balance that's created, becomes an outstanding obligation of the student, if the financial aid falls through, I could take the position that that is still a non-dischargeable obligation. But clearly, if you have the information at the time the debt is created, then the more information you have, the more it looks like a loan as opposed to a book account, and the more likely it's going to be that it's non-dischargeable.
Ed, a couple questions we have here, too, relate to student loan exit interviews or exit counseling requirements. Is there, under the notice of stay, is there anything that would block a school from still requiring completion of an exit interview, for example?
That's a heck of a question.
I'm reading into the question, if the student didn't complete one and there's a hold on their records.
Okay. If the student did not complete an exit interview and they're in bankruptcy, I would think that you cannot send them the exit interview in the mail and say, hey, complete this. If they didn't complete it and they're not in bankruptcy, of course you could do that. If they're in your institution and it's the day that's scheduled for exit interviews and the student is then currently in bankruptcy, are you prohibited from taking an exit interview? Is that the question? I would take the position that you're not prohibited.
Okay. I want to jump back into the tuition world again. Here's a question. If a housing balance is expressly added to a contract, does that make the housing balance non-dischargeable?
We're talking about dormitory fees or housing, and did the debt exist at the time? Was there a writing that included the housing balance at the time the debt was created? Or, I mean, if you're talking about damage, for instance, if they don't owe anything for rent, but they created damages, which now clearly the damages could not have existed at the time they created the debt because they're just moved in. If they file for bankruptcy, it's discovered that there are damages, I would take the position that that is still, that is dischargeable, unfortunately.
Okay. Here's a question, again, I think we may have covered this earlier, but if an institution is not named as a creditor on the discharge or in the bankruptcy, is the institution obligated to honor the bankruptcy? And I'll just add a second part to that. Let's say you have a loan servicer managing the account and their name is listed as opposed to XYZ University. What's the impact in those cases?
One of the things I stressed, or at least I tried to stress at the very beginning of this, was if an agency is notified or a servicer is notified, that's the same thing as notifying the university. If the agency or loan servicer is notified, your contract as an institution with that collection agency or loan servicer almost certainly has language in there that it's the responsibility of the loan servicer or the collection agency to notify you of a bankruptcy. So if Temple University was not properly named, but ACS Services was named, and that can be proven, obviously, by looking at the schedule of creditors, of debts, then that is going to be held to have been noticed on the university.
Okay.
Did that answer your question?
I think that answers that question. I've got one last question because we're pretty much up against the clock right now. We've got time for one last question and then just to close up. And I know we've still got a few other questions out here that we'll try and deal with and get back to you offline. But in terms of dealing with the bankruptcy process, how much of an advantage, or how reasonable is it for the school staff themselves to manage the process versus utilizing an attorney or a third-party collection agency?
The only time that there's something to manage, really the only thing that you need to do is file a proof of claim, by and large. Okay? If you're served with an adversary complaint, and again, we talked about that. One of the screens of the PowerPoint talked about the adversary complaint and undue hardship, the general exception to non-dischargeability. If you're served with a complaint, something other than the bankruptcy petition, the bankruptcy notice itself, that triggers a whole bunch of other responsibilities, and the university needs representation. If it's simply the notice of the bankruptcy and either tracking, okay, is the bankruptcy still ongoing or is it over, the university or the collection agency should be able to monitor that, no problem. The filing of the proof of claim, again, a very, very easy, user-friendly process. Okay, only if you're talking about a dischargeability issue is it something that you're going to need to get some sort of legal representation.
Well, Ed, this is Denny. Thank you very much. I have to tell you that the one thing I'm going to do next week is to go to the ERS website and go to the webinar archive, and I have to listen to this webinar again a couple of times to just to get all the information that's been shared today. This has been such an information-rich session. I can't tell you how much we appreciate you sharing all your knowledge in the area of bankruptcy.
My pleasure.
But for sure, that's certainly one thing I'm going to do, and I'd encourage everyone on the line to do the same thing, because there is just an awful lot of information that you are very willing to share with us. So thank you very much. Thank all of you for joining us today, and Steve, I'll turn it over to you.
Thanks, Denny. I appreciate that. David, thank you very much. Denny, thank you. Denny, I agree. Ed, that was just fantastic. I thought the information was exceptional. You are the bankruptcy guru. Greatly appreciate it. we have a lot of questions that were submitted that weren't answered, and Ed, I'd like to talk to you offline. Perhaps we can get answers from you to those questions, and we can send those answers out to the people that participated today. But like I said, I'll talk to you offline about that. On Monday or Tuesday of next week, you'll receive an email from us regarding the webinar. It'll have a link on there directing you to the PowerPoint with the audio attached to it for your viewing. So look for that next week. Lastly, just want to thank everyone for participating today. Again, we had a great turnout and great job by you, Ed, and Denny and David, you guys as well. Please, after this webinar concludes in the next minute, if you could take a look at the post-webinar survey, give us your feedback. It helps us out for the future webinars, and let us know what type of topics you'd like to see. We've got 3 more webinars left for this year that we're going to be doing, so please share the topics that you're interested in hearing, and certainly if anyone out there is interested in being a speaker or a presenter for a webinar, if you want to do it with a panel, let me know that as well. I'll send out my email address, so contact me. With that being said, that wraps it up. We'll be signing off on our end. So thank you all, and have a good rest of the day.